Is a contract of sale signed by the seller, who is not the owner of the property, valid? What do you think? Would such an agreement be enforceable or not? Now, contrary to what many people seem to believe, such an agreement would indeed be valid and enforceable. Whether the seller is able to, however, perform in terms of such an agreement is, of course, another question, because he would have to make sure that he does indeed become the owner of the property so that he can transfer it to the purchaser, so that he can indeed comply with his contractual obligations in terms of the contract of sale. For example, sometimes at a sale and execution, it might happen that there's a purchaser who successfully bids in respect of a property, who then buys the property at the sale and execution. Shortly thereafter, he might then find a purchaser for the property, and then he would, of course, want to sell it to that purchaser, hopefully for a profit. Then such an agreement would indeed be valid. The purchaser would then be able to acquire it in terms of the sale and execution agreement, and sell it again to the other purchaser that he has found. And those transactions can indeed be linked at the deeds office so that they can be registered simultaneously. Another example might be where someone is entitled to inherit a property and has found a purchaser for that property. Then he could also already sign the agreement of sale, even though he has not yet taken transfer of the property from the deceased estate. However, keep in mind that it is not necessary for the property to be transferred to such a beneficiary of the deceased estate first, before it's transferred to the purchaser. With the consent of the beneficiary and with the cooperation of the executor, the property can actually be sold directly out of the deceased estate, and the executor can, with the consent of the beneficiary, give transfer of that property directly to the purchaser and thereby save some transfer costs which would otherwise be payable.